Jon Williams with Manulife Securities and Williams Financial Group, and today I'm going to talk about a very important part of people's financial plans, and that is the settling of their estate and creating an estate plan. So when we talk about an estate plan, obviously the most important part of this plan is a will. But before we get there, something that I want to touch on as well that's equally as important as having a will is making sure that people have in place power of attorneys. Now, generally speaking, there are two different types of power of attorney. There's a financial power of attorney and a health power of attorney. Each of these powers of attorneys allow someone else to make decisions on your behalf if you're incapable at the time to make them. Now, often the same person has the power of attorney for both financial and medical, but not always. For instance, if, say, there's no family members that are close by, perhaps a non-family member might have a financial power of attorney to make the financial decisions for this person's behalf. But when it comes to medical decisions, the family member that may not live that locally is probably better to make those decisions on behalf of the family. So let's talk about wills. Now, there's several components of a will that I want to touch on. Number one, let's talk about beneficiaries of your estate. Number two, choosing an executor. And number three, we'll talk briefly about inheritance tax and death costs. So let's first off talk about beneficiaries of your estate. Often they're spouses, children, charities, etc. Now, one of the important parts of making an estate plan is realizing that every asset is not equal in value. For instance, say a person has a $300,000 house and they also have $300,000 in a RRSP or RIF. Now, let's say this person had two children and they thought, I'm just going to keep things simple. I'm going to leave the house to my one child and my investment portfolio, which is mainly RIFs, to my other child. You know, they each get $300,000. Well, this actually isn't an equal distribution. And the reason why is the primary residence has no capital gains on it. And so if the value of it is $300,000, essentially that beneficiary will get $300,000. On the other hand, a RIF has to be cashed out and all $300,000 is taken into income, and a tax return has to be done for that portion of the estate. Therefore, let's say 45% of that would actually have to go to taxes, leaving about half the amount to the second child that's actually getting the RIF. So it's important to understand that each asset has a taxable event and what exactly that is so that things are evenly distributed. Number two, let's talk about executors. Often clients will have multiple children and name those multiple children executors. There is this perception that being an executor is almost a good positive thing and that I'm honoring you to be my executor, which isn't really the right approach. Being an executor is actually a job, and the job of the executor is to ensure that the estate is settled according to the wishes of the will. And so the challenge with having multiple executors is that each financial institution that is trying to settle out investments, each account that's trying to get settled out, needs the signature of all of those executors. And in fact, having multiple executors can often add more complications and extend the timeline of settling that estate just purely due to logistics. Whereas in fact, it is the responsibility of any executor, if you just named one person to be that executor, it's their job to fulfill the wishes of the will. And so it really doesn't necessarily make a lot of sense to have multiple executors in most cases. Generally speaking, one person can be the executor of a will and will actually settle it quicker, more efficiently than having multiple executors. Finally, I want to talk a little bit about probate. Probate is a fee that is levied by the government. It's approximately 1.5% of the value of the estate, not on all assets, but on most assets. And it is payable upon a person passing. And so a lot of people will attempt to structure their portfolio, their investments, to avoid probate. which I think is prudent in a lot of situations, but I think people should also be cautioned, because I've equally have observed some people put multiple owners on a, say, non-registered investment portfolio. Say they name 2 or 3 of their children as joint owners on this account. Now, there's nothing wrong with that as long as everything in life goes smoothly. But the thing I like to caution people about with joint ownerships is, say there is a parent and they put the child as a joint owner. As soon as that child is a joint owner, they technically and legally own half of that non-registered investment portfolio, or that GIC, whatever it may be. Now, why is this important? Because it also means that that child's spouse owns half of their half. Meaning, if unfortunately the child that's now the joint owner on this account ended up getting divorced, their spouse actually has legitimate claim to a quarter of that account. So, the important thing when coming up with an estate plan is figuring out how to efficiently transfer your wealth to your beneficiaries, and by all means minimizing probate, but certainly not at the cost of adding on additional risk or liability when it comes to having joint owners on your investments. And just before I finish off here, one thing that I'll put in the attachments below my video here is a will planning questionnaire that Manulife Financial has produced. And it asks simple questions like, who would you like to be your executor? Is there someone else you'd like to assist with being your executor? And what it does is it's a simple 19 question questionnaire that will help start the process of figuring out how exactly you'd like to have your estate distributed. And really it's the first step in creating an estate plan, of which of course we'd be happy to walk you through. Thanks very much and have a great day.